SRIRAM's IS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello students, welcome to SRIRAM's IS. Welcome to this concept class. Fundamental rights, as we all know, are given to the citizens of India. They are also extended to the non-citizens. But what about the fundamental right of the people who are being arrested? What about the fundamental right of this person who has been arrested and put under custody? The arrest can be lawful, the detention can be lawful, it can also be illegal, it can also be arbitrary. It can be by a legal authority, it can be by a authority which is not legal, or a authority which is acting out of its jurisdiction. All these things, all the rights to protect the civil liberty of the citizens of the India and also to the non-citizens. Article 22 has been inserted in the Constitution of India. It protects those civil liberties. It in a way curtails the arbitrary nature of the state. Okay. Now, to understand Article 22, we have to understand the right to freedom. That is a category under which four important articles comes. Right to freedom contains Article number 19, Article 20, Article 21 and Article 22. These three articles, Article 20, 21 and 22 forms a very important part of the criminal justice system for its efficiency, to reduce the arbitrariness, improve the logicalness and reasonableness in whatever action the legal authorities are taking, especially the police is taking. And there is where the role of Article 22 comes in. So Article 22 talks about so many things. One of that thing is the grounds on which a person has been arrested needs to be communicated. Then it talks about the legal representation. It also talks about presenting the person who has been arrested in front of the magistrate within 24 hours. Also, it talks about preventive detention and what happens to the enemy aliens. So, clause by clause, one by one, we will understand the scope of article number 22. That is the concept class for today. Okay, it's a very important topic. It is going to help you in your upcoming prelims examination. It is going to help you in your other examination to understand this concept. Pay attention here. So, article number 22. Think about a person who has been arrested on road right in front of you. If some person has committed a cognizable offense, okay, and a police authority comes in, a police wala comes and arrests that person. Or think about a situation where the police wala has found some evidence against some person and he goes and arrests that person. What is the first thing which the person asks from the police wala? Why are you arresting me? Why are you arresting me? He wants to know on which charge I have been arrested, on what grounds I have been arrested. And that is logical also. If some police wala, if some person from Enforcement Directorate or if some person from Central Bureau of Investigation, all the lawful authorities in this country comes and arrests you, the first thing they need to communicate to you and communicate immediately to you is the ground on which they are arresting you. Now that is one of the most important foundational provision of article number 22, that a person who has been arrested, the grounds needs to be conveyed to that person immediately. Why it is needed? It is needed so that the person can create a defense for himself. Innocent until proven guilty. Now, we all know this. It is a very important provision of criminal justice system. To uphold this provision, it is important to communicate the grounds. If you do not know the grounds on which you are arrested, how will you create defense for yourself? So, it's a very important provision under article number 22. This is the first thing which you have to understand. The second thing is, you should get a legal representation of your own choice. Means a lawyer of your own choice. Who is going to protect you in the court of law? It is only a lawyer who can do that. And that legal representation of your choice has to be given to you, has to be provided to you by the authorities. That is a very important, a cornerstone provision of article number 22. The third provision, to apply a legal mind, a very important provision, a person who has been arrested needs to be presented in front of a magistrate within 24 hours. Now, why this provision has been kept under Article 22? So as to apply the legal mind, so as to see whether the arrest which was made is lawful or not. Was it arbitrary in nature or non-arbitrary in nature? Was it based on some evidence, or it was done on the whims and fancies of the government or whims and fancies of the legal authorities? To apply the legal mind, to apply the legal provision on that arrest, on that detention, it is very important to present the person in front of a judicial magistrate within 24 hours. And if a person is not presented in the front of the judicial magistrate within 24 hours, what happens? Anybody can move to the court and file a writ petition of habeas corpus. We all know habeas corpus can be filed in high courts under Article 226 and in Supreme Court under Article 32. Where is the person? Bring the body. That is what it is called. That if a person has been detained, it is the legal necessity to present the person in front of a judicial magistrate within 24 hours. So communicating the ground as soon as possible, immediately, giving the legal representation, and then presenting the person in front of the judicial magistrate. These are cornerstone provisions. Okay, these are very, very important provisions of article number 22. Think about a situation when one of these or all of these are removed. Any authority can arrest you at any point in time without even telling you on what grounds they are arresting you. And once they have arrested you, they are not going to present you any legal help. Along with it, they are not going to present you in front of a magistrate. It will be so difficult for a person. A person can be there in darkness for perpetuity. Who is going to come and see whether a person has been detained lawfully or not? Where the person has been taken? To improve upon the lawfulness in this country, to improve upon the non-arbitrary nature of the state, to improve the civil liberties, the provisions have been made under Article 22, and that is the reason why Article 22 becomes a very important provision of the Constitution of India. The grounds have to be communicated to the person who has been arrested. That is the first thing. The second thing, when the grounds are communicated, a legal representation of his choice has to be given to that person. That's the second thing. And third thing, the person has to be presented in front of a magistrate within 24 hours. All this is done to protect the civil liberty of the individual. Now, there are several exceptions also. So, there are 7 clauses under Article 22. Clause number 1 and clause number 2 talks about these 3 provisions which we have seen. The communication of the grounds, the legal representation, and the presentation in front of a magistrate. What is given from clause number 3 to clause number 7? So there has been an exception made in clause 3. What is that exception? Exception is of preventive detention and exception is of enemy alien. So think about a situation where an enemy alien has been arrested by a police authority. Now, what is an enemy alien? Enemy alien is the person who is the citizen of a country who is hostile with India or who is at war with India. Okay, the normal people, the citizens of India or the citizens of friendly countries such as the US or the Britain or from somebody from France or somebody from Bhutan or somebody from Nepal, all these people, if they are arrested, it is the duty of the legal authority to communicate to them the grounds, to give them legal representation and present them in front of the magistrate. But all these conditions do not apply to arrest of a person who is an enemy alien. It's an important thing to understand. A country which is hostile to India, a country which is at war with India, all the citizens of that country becomes enemy alien. Okay. So a person, if he or she is an enemy alien and arrested by the authorities, the authorities are not under the legal duty or responsibility to communicate the grounds of arrest, to give a legal representation to that person or to present that person in front of a magistrate within 24 hours. It is very important for you to understand this exception. There is another exception. The another exception is of preventive detention. This does not apply only to the enemy aliens, it also applies to the citizens of this country. Okay. Now think about a situation when a person has been taken into custody, a person who is a citizen of India is taken into custody by a lawful authority under preventive detention. Is it necessary to communicate the grounds? No, it's not necessary. Is it necessary to give that person the legal representation? No, it's not necessary. Is it necessary to present that person in front of a magistrate? No, not necessary. But a person who has been taken under preventive detention cannot remain there forever. At one point in time, the authorities has to tell that person the grounds on which the person was arrested. At one point in time, the authorities has to give him legal representation. Okay, and for the application of the legal mind, the person has to be taken up to the court also, at or to the advisory board. There is a provision of advisory board. So the maximum period a person can be under preventive detention is 3 months. And if you have to keep that person under preventive detention for more than 3 months, there is an advisory board. And the advisory board consists of several judges. They take the decision whether that person should remain into the custody for more than 3 months or not. Now you must be thinking, why to take a person under custody when he has not done anything wrong? Preventive detention does not apply to people who have committed some crime. It applies to normal people who has not committed any crime. On the assumption that a person can be a threat to law and order, a threat to the security, the person can be taken into custody. That is what is preventive detention. A person has not committed any crime, he has not done anything wrong, and still the person can be taken into custody. Because there are circumstances which will allow that person to create a situation which will impact the security of the country, security of the people, the law and order situation. So, okay, preventive detention is a very important tool in the hand of the administration to maintain the law and order in the country, the sovereignty and unity of the country. But again, this clause, this tool which has been given to the authorities must not be used in an arbitrary manner. Now, in order to ensure that it's not used in an arbitrary manner, there are also protections given. Okay. So, there is a protection of advisory board. If you have to keep a person in custody for more than 3 months, 3 months is a long time. For 90 days, a person can be taken into custody without the person doing anything unlawful, just on the assumption that person may do something which may impact the sovereignty, unity of the country, the law and order situation and the situation of security. So if you have to extend the period of his detention beyond 3 months, then the advisory board comes into play, and it is the advisory board which consists of judges. It can be sitting judges, it can be judges who are retired, or it can be judges, people who can be made judges, who are eligible to be judges. So the advisory board can consist of all these people, and they decide whether the 3 month period can be extended to 4 months or 5 months or not, or whether the person should be released. It's a very important protection, okay, which needs to be followed. Now, talking about the grounds, talking about the legal representation. At one point in time, legal representation has to be given to the person. Grounds have to be communicated to the person, although not immediately. In the case of preventive detention, it is not the necessity or the responsibility of the legal authority to communicate the grounds immediately or to give the legal representation immediately, but it should be done as soon as possible. Okay. Now, when the grounds are communicated, what if the ground contains some sensitive information? The sensitive information which, if comes in public, can create law and order problem, can create the security threats, can impact the sovereignty and unity of the country. Now, one of the clauses says that sensitive information must not be provided. If a person who has been arrested on preventive detention is asking for the grounds on which he has been arrested, the grounds must be communicated to him. But if that ground consists of some sensitive information, it must be written in general way. It must not be communicated, should be hidden. But again, it should not become a tool in the hands of the authority to not provide the grounds of arrest. Only the sensitive part which can create problem in future needs to be removed. Everything else needs to be communicated to the person. It is not the right of that person who has been taken into custody under preventive detention to ask for legal help or to ask for the ground. But it is, in one or the other way, becomes the responsibility, because of the civil liberty and the open nature of the society in India, and because of the provision, because of the importance that a person cannot be kept into the jail forever. The person must not be there under custody forever. It becomes very, very important to communicate grounds, to give a legal representation. But when communicating those grounds, when giving the legal representation, nothing of sensitive nature must be communicated. When I say sensitive nature, information of sensitive nature, it simply means any information which can create law and order problem, or any information which can create security or impact the sovereignty and unity of the country. Think about a person who has been detained under preventive detention. The person usually is not a common man. The person is going to be either a leader or a goon or a person from militia, or anybody who can actually create some problem. He has several people under him, or she has several people under him who follows them, and through speech, through expression, through command, the person can actually create some problem on ground, and to avoid that problem, the person is taken into custody. But several sensitive information can also be linked with that person. There can be some sensitive information which cannot be and should not be presented, or else it is going to create another problem. To avoid that another sort of problem, only the information which is necessary has to be communicated, not the sensitive information. Now, we have studied about the grounds of arrest and how it needs to be communicated. We have seen about the legal representation. We have studied about the presentation of the person in front of a magistrate within 24 hours. Also, we have known about preventive detention, the advisory board, and the grounds needs to be communicated, whether it is necessary for the legal authorities to communicate the ground in preventive detention cases or not. The rules regarding all these things, the statutes, rules, laws regarding all these things are to be made by the Parliament. That is another provision of article number 22. It gives the power to the Parliament to make laws regarding preventive detention, laws regarding arrests and detention in the country, and also laws regarding detention of an enemy alien. Okay, so these are few important things which you should keep in mind while reading article number 22. Article number 22 is a very beautiful article covering these two clauses which talks about the rights in the matter of ordinary arrest, and clauses 3 to 7 which talks about preventive detention and detention of enemy aliens. I hope you have understood this. Thank you very much for joining me in this lecture, and try to focus on whatever I have said regarding this particular article about this particular concept of arrest and detention. It is going to be of great use in solving questions and writing questions and making your essay more articulate. Article 22 forms a very important part of criminal justice system. It forms a very important parts of civil liberty, and everybody must have knowledge about it. So thank you very much for joining me. Have a nice day, and Jai Hind.